2008, as I said, the taxman has had a very easy hit in relation to managing trust cloning because it's basically been prohibited other than relation to unit trusts. Unit trusts were excluded from the abolition of the capital gains tax relief. What we've also found is that a lot of the trust clones that happened before 2008, we are still seeing audit activity from the taxman. And again, I wanted to share one tip for you, not so much because it's going to be necessarily relevant moving forward if you're looking at trust cloning, but more to highlight that the taxman will look at these things very, very closely. And also to give you another thing to keep on your checklist, because I think quite aside from the tax issue, there's a trust law issue here that's going to be relevant when you're looking to hand on control of an existing trust. So factual scenario, and if you're looking at those, they are meant to be identical. They may not quite be identical with my handwriting. Original trust and a clone trust. We're looking to say we've got 2 buildings inside the original trust and we're wanting to move one building across into the new trust as part of an estate plan or as part of an asset protection exercise. Historically, what the taxman said was that the 2 trust instruments needed to be identical in every respect in terms of their effect. And that was a really important additional part of the sentence, in terms of their effect. And what that means, if you use one very, very simple example, but one that we lost count of the number of people who got wrong, what most trust instruments will say in relation to vesting is that the vesting is 80 years from the date of the deed. So say this deed was set up on the 1st of June 2001. When you then go to create an identical deed, if you adopt that exact same wording, so from the date of this deed, and you set it up on the 30th of December 2016, then suddenly you've bought yourself, close enough to 15 years additional perpetuity period, because this trust will end in 2081, whereas this trust would end in 2097. If I've done my maths right there. What that ultimately means then is that in order to satisfy the tax officer's view of the universe, and indeed we would say probably to do any sort of trust clone just from a basic trust law perspective, you need to think about that definition under the cloned instrument, instead saying 80 years from the 1st of June 2001. So while the written terms of the trust instrument are not identical, the actual effect of those written terms is identical, because the vesting day of this second trust will be identical to the vesting day of the first trust.